In every contract, there should be provisions dealing with what happens if there's a breach or a violation of the contract. There are different aspects of the what-ifs. If there's a breach or if there's a violation or there's some sort of dispute, there needs to be a mechanism that's agreed to ahead of time as to how that dispute is going to be resolved. There are three primary ways that parties can resolve disputes. They can litigate, which means they can go to court, which can be very time-consuming, it can be very expensive, it's open to the public, and it's a difficult process. But parties oftentimes agree that they're going to litigate, or if they're silent about how they're going to resolve disputes, the default is commonly litigation in court. The other two options are to mediate, or to agree to mediate, which is where you have the parties meet with a neutral third party. That neutral third party's goal is to help the parties come to some sort of resolution, to agree as to how they're going to deal with the dispute. So it is something that's purely consensual, which can be very satisfying for the parties on both sides because no one's imposing a decision upon them. They're coming to that decision by themselves with the help of a neutral third party. And inevitably, a well-resolved mediation is one where both parties, or all the parties, walk away feeling not entirely happy, but not entirely upset either. The third option is arbitration. Arbitration is similar to litigation in that you have an arbitrator or a panel of arbitrators, sometimes it's 3 arbitrators, who will listen to the facts, will listen to the evidence, will apply or attempt to apply the law of the state that governs the contract, and will decide what the outcome of that dispute resolution is going to be. So it's an imposed decision, it's agreed upon ahead of time that it's going to be by private arbitration. Arbitration is oftentimes quicker than litigation, is oftentimes less expensive than litigation, and is oftentimes not exposed to the public. It's something that occurs privately. The parties pay for the arbitrator or arbitrators and the entire process. There are some down points to arbitration. We're not going to discuss those now, but those are the types of things that one should consider when they're entering into a contract. How are we going to resolve these disputes if disputes do arise? And it's always good to think about the what-ifs, because even though you're entering into a contract feeling great about your business partner, thinking nothing's going to go wrong, things inevitably can go wrong. So think about how you're going to resolve those disputes, and also think about whether, if there is a dispute and there are damages, whether you want to agree ahead of time as to what the monetary value of the damages may be, so that you don't have to have experts testifying as to who was damaged and how much they were damaged and that sort of thing. That's called liquidated damages, where you agree ahead of time as to what the damages can be. Well-drafted contracts will take these types of provisions into effect and will include them in the contract. You should read up on this, or if you need to, you should consult with an attorney to give you advice with regard to these types of provisions.